You are watching the Lemonade Podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hi, everybody. Welcome to the Lemonade Podcast. I'm Matt Sky. With us is Shalev Amar, managing partner and founder of Amar Law Group. Shalev brings a wealth of experience in consumer protection law, specializing in lemon law and breach of warranty cases. Shalev, thanks for joining us.
Thanks for having me.
So, what specific aspects are covered in lemon law statutes across different states?
Well, all lemon law statutes are warranty enforcement statutes. Now, not any warranty. There's a difference between the original manufacturer's warranty versus an extended warranty. Now, under the law, extended warranties are basically treated as insurance. So under those, you only have the right to repair. Under state lemon laws, which enforce the manufacturer's warranty, there's not just the right to repairs, there's also the right to have the repairs done within a reasonable number of attempts and a reasonable amount of time. And so if the repair history becomes unreasonable, there's two ways that can happen. Let's say there's too many repair attempts. At a certain point, the law says enough is enough, and then you're entitled to seek either a vehicle repurchase, called the lemon law buyback, or a new vehicle replacement. And under most lemon laws, you're also entitled to recover your attorney's fees from the vehicle's manufacturer, because otherwise most attorneys wouldn't be willing to take lemon law cases given the cost of vehicles. Normally it's insufficient to be able to recover attorney's fees as well. So that's why most lemon laws enable you to recover your attorney's fees as well. And so there is some variation between the states, but most states have what are called lemon law presumptions. So what a presumption does is it doesn't guarantee that you win, but it helps you prove your case. Typically, the consumer is the one who has what's called the burden of proof to prove their case beyond a preponderance of evidence. It just means more likely than not. So the way to look at it is, let's say you're playing a basketball game. The team that scores more is the one that wins. So the consumer has to score more as far as proving their case. Once you meet a lemon law presumption, however, it shifts the burden of proof from you, the consumer, to the company. So presumptions can vary by state, but typically the most common presumptions are either 3 or 4 more repairs for the same substantial issue and it continues to exist, or 30 or more calendar days in the repair shop, and that's deemed to be an unreasonable repair time. Some states say 30 or more business days, which comes out to be slightly longer because repairing dealerships have 6 business days in a week. So if you base it on that, it's the equivalent of 34 calendar days in the repair shop. And so all lemon laws have presumptions. There are some states that have a presumption for if the defect is so substantial that it could cause serious bodily injury or even death. In those situations, there's some states that only require 2 repairs before you have the law presumption.
Could you explain the commonalities between states regarding lemon law and the key differences that consumers should be aware of?
I'd say the main commonality is that the vehicle's repair history is unreasonable. All lemon laws at a certain point say enough is enough. The other commonality is what we were just talking about before, which is that they all have presumptions where at a certain point, it's presumed that the vehicle's repair history is unreasonable, and that's based on a certain number of repair attempts, a certain time out of service. Another commonality that all lemon laws have is they have what's called a usage fee or usage offset, where they get to deduct mileage from the refund. You don't get to use a vehicle completely for free if you get a buyback. The other commonality is that all lemon laws give you the ability to get a new vehicle replacement. The other commonality is virtually all lemon laws, except for maybe a handful in the entire country, enable you to recover your attorney's fees as well. So those are the commonalities. Now, the differences, they tend to be minor. Sometimes they're major, but for the most part, they're minor between the states. So what are some of the differences? What the presumption is set at, that's a difference. Some states, it's 3 or more repairs. Other states, it's 4 or more repairs for the same issue and it continues to exist. And some states have the substantial safety defect presumption of 1 or 2 repairs. Some states do not have the safety defect presumption. The other variation is as far as time out of service for when that would be deemed unreasonable. And typically it's 30 or more days, but in some states it's business days. The other difference is what is the lemon law period? The most common lemon law period is 2 years or 24,000 miles, whichever comes first, from when the vehicle is originally bought and delivered. Some states, however, it's a shorter time period of 1 year or 18 months. And in some states, it's less mileage, either 12,000 miles or 18,000 miles. Only a couple of states, a small minority of states, the lemon law period is based on the entire duration of the warranty. For example, the California lemon law, that is based on the entire duration of the warranty. And so that's pretty rare. Most state lemon laws have a shorter time period than the warranty coverage. What's also different between the states? What's called the statute of limitations. In some states, the statute of limitations is 30 months. In other states, it's 2 years. In some states, it's 18 months. And in a tiny percentage of states, it's only 12 months to be able to bring a claim. One other difference between state lemon laws is some require that before you file a lawsuit, you go through arbitration. Typically, car companies have that set up through what's called the BBB auto line or the NCSD or NSDS. I always get the acronyms wrong. Some states have a state-run arbitration program that's required prior to filing a lawsuit. And then there's a small percentage of states that do not enable consumers to recover attorney's fees. So that's the main differences between various lemon laws.
So Shalev, what are the key distinctions between federal and state lemon laws then?
I would say there's 2 big distinctions, and that is the period of coverage and also what type of remedy you're able to get. So first, let's talk about the period of coverage. As I was just talking about, most state lemon laws, the period of coverage is less than the manufacturer warranty. Most manufacturer warranties, for example, are 3 years or 36,000 miles bumper to bumper. Some premium brands have 4 years or 50,000 miles bumper to bumper. Then they also have what's called a powertrain warranty, which basically applies to what makes the vehicle go. Most powertrain warranties are longer than the bumper to bumper warranty. So they could be 4 years, 50,000 miles, or 6 years, 70,000 miles, or even up to 10 years, 100,000 miles. And some of the electric vehicle manufacturers, they have 10-year battery warranties that also typically go up to 100,000 miles. And so the state lemon law, like I said, most state lemon laws are a shorter period of coverage. It's typically 1 to 2 years or 12,000 to 24,000 miles. Under the Federal Magnus-Moss Warranty Act, it's actually based on the entire duration of the warranty. So as long as you have the manufacturer's warranty, that's covered by the Magnus-Moss Warranty Act. That is, so typically, it would be the 3 years, 36,000 mile bumper to bumper, 4 year, 50,000 mile bumper to bumper, and the powertrain warranties, etc. There's no artificial limitation like in state lemon laws. It's based on just how long your warranty goes. Also, the statute of limitations for the Magnus-Moss Warranty Act is typically much longer than the statute of limitations for state lemon law claims. And the statute of limitations, it basically just means the time that you have to bring a claim. So under most lemon laws, it's the statute of limitations is either 6 months after you hit 2 years, 24,000 miles. On the high end, it's 30 months from when the vehicle was first acquired. And, on the low end, it can even be only a year. Under Mag-Moss, the typical statute of limitations, there's some exceptions to this, but typically it's 4 years from when the warranty is breached. And when the warranty is typically breached is when the repair history becomes unreasonable. Now, the other major difference between state lemon laws and the federal lemon law is what you're able to get. Under the state lemon law, like we talked about before, you're able to get a repurchase or replacement. Under the Federal Magnus Warranty Act, you're typically only able to get what's called diminution in value, cash and keep compensation. It's like what it sounds, it's cash compensation with keeping the vehicle. And so it's basically like a partial refund because you didn't get what you paid for given the problems that you've had with the vehicle, the inconvenience. It just wasn't worth what you paid for it. The easiest way to look at it is you bought a new warranted vehicle and you really got the equivalent of a used, worn down vehicle that should have cost you less. So those are the main differences between the state lemon laws and the one federal lemon law called the Magnuson-Moss Warranty Act.
Can you discuss a notable example where federal lemon law provisions differ significantly from state provisions?
Yeah, it's similar to what we talked about. It's basically that the warranty coverage period is just different under the federal lemon law. It mirrors exactly what's in your manufacturer warranty, and under state lemon laws, it's not based on that. It's typically 1 to 2 years and 12 to 24,000 miles. I would say another difference is under state lemon laws, there are what are called mandatory attorney's fee shifting provisions. By mandatory, they say that a manufacturer shall or must pay a consumer's attorney's fees if they prevail on a claim, and typically settling a claim is considered prevailing on it. Under the Magnuson-Moss Warranty Act, it says that a consumer may recover attorney's fees. So it's not mandatory, there's some wiggle room there, but for all practical purposes, most companies do agree to pay attorney's fees for Magnuson-Moss Warranty Act claims.
And how do lemon law protections differ regarding new vehicles versus used vehicles?
Well, some state lemon laws do not cover used vehicles whatsoever. It varies state by state. In some states, even if you bought a used vehicle, as long as you still fall within the lemon law period, say the lemon law period is 2 years, 24,000 miles, that is, and let's say you bought a vehicle that's a year old that had 10,000 miles, you would still have another year and 14,000 miles of lemon law coverage. Some states, though, only apply to new vehicles. So even if you bought only a slightly used vehicle, you would not have state lemon law coverage. The federal lemon law, though, does not make any distinction between new and used. You just need to still have manufacturer warranty coverage and an unreasonable repair history, either too many repair attempts for the same substantial problem or too much time in the repair shop, and then you would have federal lemon law coverage.
And are there specific conditions or thresholds that must be met under federal lemon law that differ from state requirements?
Not necessarily, although there could be a couple of situations. I would think that the main one would be in the states where there is a presumption for a substantial safety-related defect that could cause serious bodily injury or even potentially death. You only need 1 or 2 repairs. I would say under the Magnuson-Moss Warranty Act, you would need at least 3 repairs for the same problem for it to take effect. Also, at least 25 or more days in the repair shop. So I would say that's the main distinction. The second one would be that under some lemon laws, you have to have a brand new vehicle for it to apply. Again, under Mag-Moss, the vehicle does not have to be brand new as long as it's still covered by the manufacturer warranty. And also, under state lemon laws, the repairs have to be within the lemon law period, other than, which tends to be 1 to 2 years or 12 to 24,000 miles, other than a couple of states that are based on the entire warranty period, like California. But the difference is under Mag-Moss, even if the state lemon law period has expired, as long as you have an unreasonable repair history that's still under the manufacturer's warranty, then you could still bring a Magnuson-Moss Warranty Act claim. Like, so for example, let's say there are powertrain warranty repairs that happen at 30 through 45,000 miles. That would be outside most state lemon law periods of 24,000 miles, but you would still have a Magnuson-Moss Warranty Act claim if you have 3 or more repairs for the same problem.
And what's your advice for consumers navigating lemon law disputes across different states with different statutes? There's a lot to keep track of.
Well, I would say first, get informed. So Google your state lemon law. So for example, if you're in Washington, just Google Washington lemon law requirements and educate yourself. There's various attorney websites that will explain the law to you. There's also sometimes state attorney general websites that will explain the law. And so just educate yourself about your particular state lemon law requirements. Secondly, always, always, always make sure, and I know I sound like a broken record and I bring this up a lot to clients and consumers, always make sure that you're getting work orders and repair orders after your vehicle has been repaired under warranty. Make sure it lists the complaint, the diagnosis, and the repair, the correct time out of service, the correct mileage. You've got to get repair records. That's extremely, extremely important no matter what state that you're in. And thirdly, I would say don't threaten car dealers or manufacturers with lemon law claims or with attorneys that could backfire and blow up in your face. Just don't do that. It's better to just consult with an attorney. Don't make any type of threats that could cause you problems.
And how do attorneys, when you do consult with an attorney, approach lemon law cases differently when dealing with the federal versus state level claims?
Well, under the federal claim, what the attorney is going to try and get you is cash and keep compensation, basically because your vehicle wasn't worth what you paid for, your aggravation, your inconvenience, your loss of use. Under the state lemon law, there's a more wide variety of results that they could try and get you. So they could try and get you a buyback or a new vehicle replacement or cash compensation. And then basically it would be up to you to decide what works best for you. Of course, the other side would have to agree as well in terms of settlement. But when the state lemon law applies, that gives you more negotiating leverage with the company, even if you end up with cash and keep compensation, because the company is factoring in the fact that they could potentially have to reacquire the vehicle. They prefer not to do that just because it's more expensive for them administratively. When they buy back or replace a vehicle, they have to take it back from you. So they typically pay a third-party company to handle the reacquisition process at a local dealer, but that's not it for them. Then they have to label your vehicle as a lemon and they have to wholesale it at an auction for a loss. So there's just a lot more involved with buying back or replacing your vehicle. They prefer to just cut you a check and basically say, hey, we're sorry, but the check will tend to be higher if you have the state lemon law because they're trying to avoid those other administrative and time burdens.
As we wrap up, if you had one key takeaway for listeners, obviously we covered a lot of space in lemon law. Is there one that you would hope they walk away with?
The main thing is to just know that you have rights, and that a lot of consumers have the mistaken belief that, well, gosh, as long as they're trying to repair my vehicle under warranty and they're not charging me, there's not much I can do. But that's not true at all. It doesn't matter if the repairs were for free. And by the way, that's the warranty wasn't free. As we all know, when we buy a brand new vehicle, it tends to be much more expensive than a used vehicle. And part of what goes into your new vehicle price, although it's not separated out as an option, is the fact that it comes with a brand new manufacturer's warranty. Those warranties have value. For example, if you buy an extended warranty, it costs you money. Sometimes it can be several $1,000s because, the repair coverage has value. So when you're buying a brand new warranted product, you're paying for that warranty, first of all. So the repairs are not for free. And as we've talked about before, at a certain point, enough is enough. When you've had too many repairs or too much time without your vehicle in the repair shop, you have rights. You have different types of compensation that you would be eligible for. And under most state lemon laws, and also under the federal lemon law, you could also recover your attorney's fees. So to just understand that you don't have to take this lying down, you don't have to trade out your vehicle for a loss. You don't have to just, grit your teeth and bear it. The law is there to help you either be compensated or to be able to get out of the lemon vehicle.
Well, that's been our show. Thanks again for listening to the Lemonade Podcast. The Amar Law Group legal team operates throughout the West and Southwest. Check them out on social media and the links below. If you're in the Arizona area, find them on ArizonaLemonLawAdvocates.com or enter your state and LemonLawAdvocates.com. Shalev, thanks so much for your time.
Thanks for having me.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.